Today I have with me Charles Henshaw of Furr and Henshaw, a law firm out of Myrtle Beach with a statewide practice, particularly in medical malpractice. They've been doing it for about 40 years, and I think universally known in our bar as one of the best, if not the best, long-running medical malpractice firms in our state. And I just wanted to, one, introduce you, Charles, and two, if you wouldn't mind, just kind of explaining to everyone how you came into a co-counsel relationship with me, and then we'll kind of walk through what that looked like for your clients.
Well, thank you, Will. I'm really glad to be here. I really appreciate the work y'all done to help us with some cases that we had, and I'm glad to talk about those cases and perhaps persuade other people to recognize the work that y'all did. So thank you.
So can you just tell everybody what led up to you partnering with my firm, Richardson Thomas, and specifically me?
Well, actually, Furr and Henshaw has been in existence for more than 50 years, and we are a niche practice, but it was only two lawyers, Farrell, Furr, and me. And we did what I like to think was very high quality medical malpractice work. We almost did exclusively medical malpractice. We didn't do much else. These are very complicated cases. They're very high risk cases. They're very expensive cases to bring. An auto accident case might be brought to trial or filed and brought to court within a matter of months. A medical malpractice case normally would take 2 to 3 years to work it up properly, to do everything that has to be looked into. Well, my partner, Farrell, got sick, and we had to start slimming down the practice, and we began to realize that the resources that we were going to be able to bring to some of the cases that we had was not going to be adequate. So we decided that we would start looking for firms or a firm that could come in and do the same type of job that we could at the same level that we could bring the same resources that we were willing to invest in the case and that they were willing to invest. We looked for certain characteristics. We looked for experience. We looked for integrity. That was a big thing for us. We wanted to have a firm that we could turn our clients over to, that we knew had a lot of integrity. We looked for a lot of enthusiasm. And we found that with you and the Richardson Thomas firm. And we're very appreciative of the work that you did. We had already made pretty good progress on these cases, but we really needed the extra power that y'all could bring to the case to finish it up once Farrell got sick.
One of the things I know we took a number of your cases, and we're going to focus kind of on this on two, since we don't have time to talk about all of them. Due to confidentiality, we can't talk about the names of the defendants, but we can talk about the factual scenarios. But before we do, you mentioned, how complex and expensive medical malpractice is. And I think for people who don't know this practice area, if you get in a car wreck and you just tear your shoulder, a lawyer might take your case because it's not expensive to bring it, just economics-wise. But to bring a medical malpractice case, you got to have some sort of what really we call a devastating injury, whether a death or it changes your life. So can you talk a little bit about what it's like to have a firm that understands the empathy required to navigate, specifically a family, through this kind of issue?
Well, these cases, if they go all the way through a trial, in the last 3 to 4 years, I haven't had one that could be handled with the expenses of it for less than $100,000, and that's probably even a very conservative estimate. It is often getting up to $150,000, $200,000, and I've seen them go higher than that. You have to have experts. You have to have, for every doctor that you're making a claim against, you've got to have at least one expert and maybe more to come in and say, this is what the standard of care is. This is where the doctor deviated from the standard of care. This is the reason that the patient was made worse off than they were when they first got sick and went to a doctor. That's one of the things. But the other thing that a lot of people may not understand is how much you've got to be able to understand the language of medicine to be able to pull the case together. It's not as simple as just simply going out and reading back a medical record. You've got to understand what those words mean and what they mean in the context of what's being said there in the medical record. A lot of times we're able to figure out cases by reading between the lines. Many times it's what the nurses didn't say. And one of the cases that we may talk about had that sort of issue in it where there were things that because the nurse didn't make a statement, we began to realize that something else was going on, and then we had to go and investigate that, and very often y'all went and investigated that, and it ultimately caused the defense to realize that, yeah, they've got it figured out.
So I think we can pull on that thread. We'll talk about the first case, and this case involved the death of a first-time mother and the death of a child. And I know when you brought us that case, we were focused on one type of issue with what involved a cardiologist. And I think we were able to peel back that onion a little bit and realize that, I would like you to elaborate on this, with the way that healthcare has moved, this team approach, and how we were able, with your help, to piece together not only that there was a lot of misses leading up to the care, but really, to your point, there was something that was missed, not followed up on, specifically a test that would have shown this woman in heart failure and saved a baby's life and a mother. Can you talk about what your experience was like with us to sort of peel back that onion and what we were able to do with your help?
Yes, and I think what we need to understand is, first of all, this was a 34-year-old woman in her first pregnancy. She had a long-standing cardiac problem, but it was not prohibitive of her having a successful pregnancy and delivering the baby. And she got pregnant and got all the way up into the 37th week of her pregnancy, which is really 38 weeks is the normal term for a pregnant woman to deliver. So, but she began to have some cardiac problems, went to a hospital, and they basically failed to diagnose or to adequately treat that cardiac problem. And the obstetrician in the case, despite the fact that the child could have been delivered at that point, decided we'll just wait and see how things go. Well, it was obvious things were not going well. And she comes back, she gets discharged from the emergency room. She comes back 3 days later. She's in severe cardiac distress, ultimately becomes comatose, I believe. The baby doesn't get the oxygen that it needs, still hasn't been delivered. And so ultimately, both the mother and the child died, leaving behind the husband, who was absolutely devoted to his wife, loved children, and it was a devastating injury.
And I don't want to get too much into the details because we're not here just to talk about, how to litigate a medical malpractice case. I think more so, when we took over that case, and you correct me if I'm wrong, we were able to find different pockets in liability than the initial thought process, I guess, from the initial case being brought, just due to us picking it up. Y'all would have found it too. I don't mean it in that way, right. But peeling back that onion is what led to ultimately, I think, a recovery that was, I think you can agree with me, much higher than what you would normally see in these cases.
That's right. At the point that we got you involved in the case, I wouldn't say we absolutely just turned it over to you because we had an association, but what we needed was somebody who could come in and start doing the legwork that was necessary to do all the depositions. We had filed the case. We had pretty much determined what theories of the case we could utilize. And we asked y'all to come in and basically take the lead in the case because it meant going out and doing a number of depositions. In that process, y'all did turn up additional facts. I mean, that's what happens in medical malpractice cases is you just cannot go on the record. If you just went on the record, you would have half the case that we ultimately had. And so by investigation, exploration, just good medical work, with I think the help of a nurse, with the help of doctors, we figured out what went wrong that kept this mother from getting, first of all, the cardiac treatment that she needed, and what went wrong in terms of the obstetrical care that she needed that would have saved both her and the baby.
I mean, ultimately, in that case, the chief medical officer of the hospital admitted under oath that they didn't get the care that they deserved after we were able to put those pieces together.
Exactly so.
Yeah. And so switching gears a little more to the human side, Charles, you mentioned our client who was alive, who lost his wife and his firstborn child. Can you talk about how you approach that when dealing with a client like that and to navigate through this process, and then how you felt we did on that?
This man was absolutely devastated. I mean, I was first called by another member of the family who said, you know, here's the situation, here's what's happened in this case. And it was difficult for him to even come around and see a lawyer. But he finally did. He was just salt of the earth kind of person, but he continued to be devastated. It was very important that we understand that and appreciate that. That's not unusual in a medical malpractice case. These injuries have an emotional component to them that lasts the rest of their lives, and that's the way that he was. But the client needs to you need to be able to have a client who can work with you, who can understand the case. So you've got to spend time explaining to them what's involved in the case, what all the issues are. There's a number of options that they can take that they have to make a decision about. That's not the lawyer's decision. It's the client's decision. And you have to respect that, and you have to give them the opportunity to learn the case themselves and then say, this is what I want to do, or this is how I think we should proceed. This was an amazing client. I mean, I don't think anybody that's met this man feels differently than that. I mean, that's all I can say.
I think one of the tricky things I'd like to know your thoughts on it in dealing with these medical malpractice cases is it's one of the few times in litigation where we are saying that someone screwed up while everyone agrees that person was trying to help our client. You know, I mean, when we go in medical malpractice, very rarely, and I think when we bring up the second case, maybe that's arguably not true, but when we bring a case against a hospital or a healthcare system, everyone's in agreement that hospital and healthcare system was existing to help our client. But because of what they did and deviated from the standard of care, they now owe recompense or money to our client. And navigating that in a way that is compelling, not only to the defendants if they're going to settle, but a jury. Can you talk about that kind of dichotomy, how hard that is in your experience?
I'll try if I'm understanding what you mean, and I think in the context of this case, I believe I do. Yes, certainly they were trying to help this client, this woman, but they had a problem in their system, which was the real problem, which did not allow them to fulfill their standard of care duty to any patient that came into the hospital. This could have happened to other people because of the system that they were using. And so we not only needed to understand the medicine that was immediately being applied to our client, but we had to understand how the system worked at that hospital that precluded the doctors from being able to do what they were supposed to do. In some ways, you could say this woman fell between the cracks in a general sense. She should have been followed more closely when she was in the hospital. She was not. There should have been at least one test, one significant test, that would have made the difference to understand what her heart condition really was. It did not get utilized. And because of that, by the time they discovered it, it was too late. She was already in circumstances that were beyond bringing her back. If that's what you mean.
I think it is. And I think just to put a finer point on it, when we get these cases, and I'm sure it's your experience too, Charles, and certainly is as we've been working with you, what happened really isn't in dispute. I mean, the medical records tell you what happened.
And they admitted
that.
And
it's the why.
And when confronted with it, it's very rare that a doctor will actually admit that they did something wrong in a way where they did it without making a direct admission. They basically said, this woman should be alive today.
And that's because we had figured out why.
That's
we
because
know what happened is a test was missed.
Right.
Why it was missed is because of a handshake agreement between two doctors that nobody knew about, passing a patient back and forth that the hospital administration failed to control.
And it's some question as to whether the hospital administration even knew about the agreement between the two doctors, despite the fact they have pages and pages of policies and procedures that are written out. This was a policy that was different than those.
And I think too often, at least when I'm dealing with people who don't deal in the medical malpractice arena, I get the story of what happened, all right? And then you're never going to prove the case and you prove why it happened. And I think that transitions into our next case that we worked on. And I'll just kind of give a factual scenario so we can kind of understand it. This was a woman who had had multiple pregnancies prior. She had a history of preterm labor, which just means that you're giving birth sooner than you should. One of the ways that doctors control from that is by putting in what's called a cerclage, which is a stitch that stitches the cervix closed. So you don't have dilation, which is just opening of a cervix earlier in the pregnancy than you should. But obviously with a cervix that's stitched closed, you can't give birth vaginally without that being removed. In this case, again, full-term pregnancy, a little short of 38 weeks. She comes into the emergency room. She still has the stitch in her cervix. And despite indications that baby wasn't doing great, the doctor didn't come in for a period of about 4 or 5 hours. That's what happened. And then when we took over the case, and you were working with us, we were able to dig into why it happened. And can you talk a little bit about what we were able to do working together that's generally different, I think, than what medical malpractice lawyers would do?
Right. And in this case, I can tell you that we had met with the client. We had obtained all of her medical records. We had all the medical records reviewed first by a nurse and then ultimately by expert doctors. They were all in agreement that what needed to be done was to get this baby delivered, and if they had done that, the babies could have been saved from significant brain injury. Ultimately, that's what happened. What we didn't know was some of the personal reasons as to why the doctor did not come to the hospital to deliver this baby. and why it took so long for her to get there. And that's where, and so by the time we turned it over to y'all, that was still yet to be determined. And y'all just did an amazing job of figuring that out. That it kept asking, well, why isn't she coming? What is going on here? Nurses were saying she wasn't coming, but they really weren't saying why. The doctor, of course, wasn't saying why. And ultimately, it had to be pushed. It had to be pressed. That's what y'all did. And ultimately, the defense began to realize that they were at risk if they continue to just hold back, and they agreed to settle the case for essentially policy limits.
Yeah, and so this was what we call birth injury cases, and the baby had an extreme hypoxic injury to the brain. So baby, in this case, needs 24/7 care. We were able to recover enough for this family that I think we can all agree was literally life-changing. And now they're going to be able to buy any house they need, any tools they need to help him. And then the rest of the family, I think it gets lost in these birth injury cases. The baby has suffered a devastating injury, and their life is never going to be okay. But the family who devotes to that child is impacted not the same, but significantly as well, whether that's the brothers, the sisters, the mother, the dad.
Well, they were an amazing family, but it's not, we see a lot of this. When the baby is born with a birth trauma like this, very often it's a deprivation of movement, or deprivation of intellect. In this case, it was global. The baby requires suctioning 24 hours a day. And the mother and the father have just dedicated themselves to making sure that that baby is taken care of, as you say, 24/7. This baby lives in their house. That requires all kinds of special equipment. It requires special monitoring. They need to have respite care. They wear themselves out trying to take care of it. It will cost a fortune to just take care of this baby, unfortunately. But they're willing to do it. And now the hospital is participating in that, the doctors is participating in that by the settlement that they've given in the case that allows for a lot of that to be paid for.
And in this case, I mean, I think what we can say is where we kind of thought outside of the box is that the reason the doctor did not come in was not clear, and no one could answer the question to us directly in depositions or anything else. So we went out from my prior experience as a federal prosecutor and got an ex-FBI investigator that ran down this doctor's history, and we were able to determine that there was a reason that certainly wasn't a medical reason that could have led to that delay. And that exposure, I think, ultimately led what is really an insurance company behind a large medical practice to turn over all the money that they had, not close to it.
And that kind of aggressiveness is what we were looking for when we went out to find a law firm who could come in and help us with the cases that we needed additional support because of Farrell's illness.
And I will say thank you for putting us on that case, not only because it was interesting and fun to work on, but truly one of the highlights of my career was being with that family when that settlement got approved, because I could hear not only, well, the mother was crying and the father's thanks, but the siblings being so happy that their life was about to change in a way. They all were devoted to that child, but everybody's life was literally going to be better. And you could feel that. I was in their kitchen. We were doing it through WebEx, and it was one of the things that I'll never forget for the rest of my life. And so I do want to thank you for putting me on that. I guess in closing and walking through this, I mean, I know that we're continuing to work in a co-counsel relationship. As somebody who's working with us, if you were going to say, why they should, and then what's the best way to get out of it for your client and you. I mean, even just at a global way, could you explain that? I know that's a tough question. I mean, one, why partner with us? And two, if you do, what's the best way to go about it to get the most for you and your client?
Well, first of all, I have very much enjoyed working with y'all because y'all speak the same language that I do. You understand the medicine. I remember that when we first met, you brought a nurse with you to my office. We sat down, we discussed the cases. As I said, the language of medicine is somewhat unique. You really do need to understand it. The little nuances in the language can make all the differences to what it means about what's going on with the patient, why the patient's sick, what needs to be done for the patient. So I know that y'all speak my language, and I very much appreciate that. But it also tells me that if you are, but I'm like you, I get a lot of my cases from other lawyers making referrals to me. So those cases, those lawyers come to me, and very often they're not medical malpractice cases. They're looking for a lawyer who can take on a medical malpractice case because they understand it, because they know how to work it up. They know how long it's going to take. They're willing to apply the resources that need to be done. And, I generally ask them to give me a rundown of the case, a summary of the case. I ask a lot of questions about the client. What is the client going to be like? And then I ask for them to make arrangements for the client to meet with me so I can discuss the case with the client. That's how we develop the suspicion as to whether or not there is or is not a case. It starts with a suspicion. It does not start with an absolute belief that, yes, this is a malpractice case, or no, this is not a malpractice case. It has to start, though, with a suspicion. We have to be suspicious. We then have to be able to go out and find experts, and there are experts and then there are experts. But to get the best experts, again, it's talking their language. It's knowing when an expert really believes that the case has merit, and when the expert is just saying, well, I'll come along and I'll give you some, basic testimony, but I'm not going to give you full support. And you don't make your decision about the case until after you've gone through these experts and tried to determine whether or not they really believe that it has merit. If you do that, you go in with a pretty solid base behind you with a pretty good amount of support, and the case can be successful, but it's going to be a long haul, and very often the clients need to have explanations along the way as to what's going on with the case, why it's taking as long as it is, what needs to be done next, so that they can fully appreciate everything. And if they do that, it becomes a team that all works together to develop the success of a case.
I think we were able to do that on this, on the case at least.
Oh,
that we've
absolutely.
worked on, yeah.
And I have to say, I remember on each of the cases that I introduced you to the clients. We had a meeting, and you came to the meeting and met with my clients, and we of course we questioned how they would how they would react to you, whether they would be okay with accepting you coming into the case. And by the time each of those meetings was over, they loved you probably more than they loved me. So
I will say, I just want to, maybe we'll cut this in later, just because I always like to bring it up when we talk about medical malpractice cases. I think a lot of people have the misconception that a bad outcome leads to a medical malpractice case.
Right.
And I just always have described it as, we get this from either other lawyers or people calling in directly, this giant funnel of bad outcomes. And the ones that actually get to a filing standpoint at least in our firm, and I think it's probably true for you, I'd love to know, I mean, maybe 1 to 2% of the total cases that you looked at,
that's
if
about,
not
you
less?
know, the way after 44 years of doing medical malpractice, the way I describe it is this. You need to think in the context of how many people do you know that have gone to the hospital and had a bad outcome, and there was never a lawsuit because there was never an allegation that the doctors did anything wrong. One of the things about medical malpractice that makes it so difficult is you're starting with a sick patient. And what you're saying is that that patient was made sicker or that patient was killed when it was not necessary. That patient could have recovered, but instead the patient ended up being directed down the wrong path. But look at all the number of people who go to a hospital and they have a bad outcome, and nobody is saying it was malpractice. It was just their unfortunate circumstance that their sickness caught up with them, and doctors, despite doing everything that they were supposed to do, were not going to be able to either save that patient or prevent further injury. I've always thought, and I'm not sure exactly what the numbers are, but my own feeling is that less than 1% of people who get medical treatment actually have reason to make claim that it was because that malpractice occurred. If malpractice was the norm, then it wouldn't be 1%. But the norm is standard medical care. It's that 1% that gives you a case of medical negligence or medical malpractice.
And then I think I've seen, at least in my experience, I've been doing this a lot less than you, Charles, but as we've seen the commoditization of medicine, you know, you've seen investment from either private equity or you've seen hospitals take over private practices and doctor-owned practices, that the doctors are being put in a position to be an economic engine rather than treating their patients. And a lot of my cases, and I'd love to know your opinion on it, is not the doctor doing something wrong as the doctor being in a position where he could never do it right in the first place. He or she can do it right in the first place, just because of the numbers, the amounts, how much they're getting pushed to do. Are you seeing that more and more?
Absolutely, and I think everybody is. I mean, you go to a doctor, and does he spend as much time with you now as he used to? Well, the fact of the matter is that doctors are being told you have so many minutes per patient to do an examination, come to a decision about what they need in terms of their medical care, and then put that plan of action into action. That's big time medicine that's causing that. I think the standard of care is just being generally compromised by a failure of the overall networks to be able to bring more elements into play on each patient's needs, so that they can be given full medical care for their full medical condition. And each doctor is sort of just out there doing their own thing, and then without a whole lot of regard for what all the other doctors are doing.
And then one other topic that I wanted to bring up with you, because I think it's been extremely valuable in the cases that we've done with you, and I think that you had an expertise in it before that I have benefited from, and that a lot of people don't understand, is since we've gone to electronic medical records and EMR systems when you're going into a hospital, things are generated called audit trails, meaning everything that's done in that patient's file, not just the notes, but literally everybody looking at a file and looking at a note, looking at an image, opening it, how long they opened it, you name it, that is being recorded by these systems, and they're required to under federal regulations. Understanding that, I think a lot of the defense lawyers don't understand that. Frankly, I don't think the doctors, the people who are doing it, it's just the administration. But us being able to understand that, to peel back that onion, how valuable to be fluent in that language, not just medicine, but audit trail and the technology side of this. Do you think that now is moving forward in this area?
If you don't understand how to do an audit trail, how to review an audit trail, or at least get people in who can help you review an audit trail, and there are lots of people who don't even know about audit trail existing. But if you don't, then you shouldn't be doing a medical malpractice case, because it's like the record that tells you the truth about the record that they made public. It tells you who was in the room, and it tells you often tells you people in the room that don't show up on your patient record. It's in terms of the law of medical malpractice. This audit trails are relatively new. Actually, they go back more than a decade. They've been in existence. We're now learning how to use audit trails to read between the lines of what's in the actual patient record. And by doing that, it makes all the difference in the world many times.
And if you're partnering with somebody who cannot understand the difference between, a main Epic EMR system and ancillary systems that are generating separate audit trails to be able to correlate the medical data across all of that and when it's happening, I think you're going to miss a lot in these medical malpractice cases. I mean, we've used them in ours, and to great effect. And mainly, it shows somebody who said something that they're not telling the truth. Yeah, that normally is what comes from.
Absolutely. And not only do you just have to not only understand that there is an audit trail, there are different brands of auditing software, and each one has its own peculiarities. And so you need to be familiar with the different brands. There's a lot to know. Medical malpractice is as I said, a very highly niche area of the law, and it's not that just anybody should be doing it because they heard, oh, I heard my friend got a good verdict in a medical malpractice case. They need to go out and find somebody. If they want to learn it, they need to work with somebody who does it. In our case, we didn't need to find somebody who knew more than we did. We needed to find somebody who knew as much as we did to help us continue to pursue the case because of what had happened in our law firm. And I very much appreciate what y'all been able to do.
Well, Charles, thank you so much for talking with me today. And I know we've got other cases to work on. I look forward to keep working with you. And I really, really appreciate the opportunity to help these people with you.
I appreciate it. Thank you.